Hi guys, welcome to the channel. Please don't forget to hit that like button and subscribe if you haven't already. So Destiny Payton from Love and Marriage, Huntsville ex-husband LeBerick Williams seems to still be out for blood. The two divorced in April of 2021, and ever since then they have been tied up in legal battles in court. And so another motion has been filed in the courts as of April 17th, 2026, and that's the update we're going to get in today in this video. Official court documents will be visible on the screen. You guys can read along with me. Let's get straight into it. Now you can see in the top right corner, these documents were electronically filed April 17th, 2026 in the Circuit Court of Madison County, Alabama, and LeBerick is the plaintiff, Destiny is the defendant. And the document reads, amended counter petition for contempt and counter petition to modify. Comes now the plaintiff, LeBerick Williams, by and through the undersigned counsel and files the following amended counter petition for contempt and counter petition to modify in this action. Number 1, the parties hereto were divorced by judgment of this court hereafter the prior decree on or about April 12, 2021. Number 2, thereafter, the prior decree was modified by this court's final order of modification in .01 action between these parties entered on May 1st, 2023, which incorporated the parties' settlement agreement dated April 28th, 2023. Number 3, most recently, this court entered a final order in the .02 action between the parties on August 14th, 2024. Number 4, although the defendant appealed from said final order, the Alabama Court of Civil Appeals affirmed this court's order and has certified the judgment. Number 5, for procedural purposes, the father notes to this court that the execution of the final order entered August 14th, 2024, was not stayed by order of this court pursuant to the Alabama Rules of Civil Procedure. Number 6, further, the final order was not stayed pending appeal under the Alabama Rules of Appellate Procedure, as the defendant mother failed to obtain and post a supersedeas bond with the filing of her notice of appeal, despite the fact that she claimed to the court that she had done so. Number 7, as a result of the mother's failure to duly obtain and post said supersedeas bond, the final order was in effect and the parties were obligated to follow said order, with interest occurring on the judgments entered therein and not paid by the mother. Counter petition for contempt. Number 8. Since the entry of the most recent final order, the petitioner mother has willful and deliberately refused to abide by the said decree and final orders as follow: by interfering with the father's telephone contact with the minor child, by withholding the minor child from the father and otherwise refusing to allow him to exercise his custodial time, by refusing to provide makeup time to the father for the custodial time he was not able to exercise as a result of the mother's action, by repeatedly being late for custodial swaps, by repeatedly failing to provide notice or otherwise withholding information related to the child's medical appointments and testing, preventing the father from being able to attend or participate in the same, by attempting to subvert the father's education decision making authority by asserting unproven, unagreed medical issues as education issues, including by attempting to obtain a 504 plan for the minor child, by repeatedly failing to appear and bring the child to his scheduled medical appointments, by preventing the father access to medical information / documentation of the child, including the child's vaccination records held by the Alabama Department of Public Health, by preventing the father from being able to pick up the child's prescription medication from the pharmacy, by failing to provide the father with the results of medical / psychological testing undergone by the child, by harassing the father, by the repeated making of unfounded reports with the authorities, including law enforcement and the Department of Human Resources, by failing to satisfy the judgment entered against her in the in the point zero 0.02 action, and by making social media posts, holding speaking engagements, and otherwise publishing public content that impliedly relates to the father of his family, including in connection with her Destiny's Law Foundation platform centered on the narrative issue of surviving domestic violence. Number 9, the petitioner mother's violation of the prior decree are willful, and therefore the petitioner mother is in civil and criminal contempt of this court. Number 10, as a result of the petitioner's mother's failure to abide by the prior decree, the respondent mother has incurred attorney's fees and costs in this action, enforce the terms of the said decree. Number 11, the facts and circumstances warrant an award of attorney fees for the respondent father. Counter petition to modify, or in the alternative, petition for declaratory relief. Number 12, the prior decree awarded the parties joint legal custody of the child, with the father possessing decision-making authority in the areas of education, civic, and extracurricular activities, and the mother possessing decision-making authority in areas of medical, religion, and culture. Number 13, since the entry of the prior decree, there has been a material change in circumstances, which calls for the modification of the prior decree. The father avers that legal custody is due to be modified to afford him medical decision-making authority, and that such a modification is in the best interest of the minor child. Number 14, the father can introduce evidence which will show that the best interest of the child will be promoted by the requested change in legal custody. Number 15, the father avers that medical decision-making authority should be granted to him and divested from the mother, and that such a change would be in the overwhelming interest of the child. Number 16, however, should the court decline to make such modification to legal custody, the father would request in the alternative that this court take up and consider the issue of decision-making authority where the areas of education and medical overlap or are closely related, specifically in the context of individual education plans, IEPs, 504 plans, or other similar education tools implemented by the school system. The father requests that this court enter a declaratory judgment determining the rights and obligations of the parents as joint legal custodians of the minor child where matter of education are affected by the mother's exercise of medical decision-making authority. Wherefore, the respondent father requests the court take jurisdiction of this counter petition for contempt and counter petition to modify, and that upon a final hearing, Your Honor will grant unto the respondent father the following relief. Number 17, by finding the petitioner to be in knowing and willful civil and criminal contempt of the court's prior orders. Number 18, by punishing the petitioner for said contempt as allowed by the Alabama law, including 5 days incarceration for each separate act of contempt. Number 19, by punishing the petitioner for said contempt as allowed by Alabama law by imposing a fine. Number 20, by revoking the suspension of the sentence of the petitioner's previous conviction of contempt and ordering her incarceration for the term imposed under the final order of the .02 action entered by this court. Number 21, by modifying the award of legal custody under the prior decree to afford the father medical decision-making authority as to the minor child in addition to these categories already held by him. In the alternative, by entering a declaratory judgment determining the rights and obligations of the parent as joint legal custodians of the minor child, where matters of education are affected by the mother's exercise of medical decision-making authority. Number 22, by awarding the respondent attorney fees and costs incurred in this matter, and by granting any additional relief to which in equity and good conscience the respondent may be entitled in the premises, and it is signed by his attorney. Drop down below and let me know what y'all think about all of this in the comments. Don't forget to smash that like button, and I'll see you guys in the next one. Bye.